Good morning, friends. Welcome to your judicial system. And I am Fred Lewis. I have the privilege of serving you as your Chief Justice. And while I'm in Tallahassee, all of us are vitally concerned at what's happening in the local community today, as you have reported for jury duty. And make no mistake, I use the phrase your judicial system because this system does belong to you. It will not operate without you, and it exists solely to serve you. It does not exist to serve the judges. It does not exist to serve those who work within the building, but it exists only to resolve disputes between our government and the citizens, between citizens, and involving businesses when those disputes cannot be otherwise resolved. Now, I know all of you have come here this morning with different anticipations and from different settings and from different circumstances, and we understand and recognize that. And we understand the sacrifice that many of you have had to make to be here this morning. But I hope you truly understand that by your being here, whether you serve on a jury or not, that it is extremely important that you be here because so many cases will be resolved in other parts of this building while you're sitting here waiting, because those individuals know that a fair-minded group of individuals are here ready and prepared to hear the evidence and make a decision. I think you need to understand that the reason you're here is that we trust you, the citizens of the state trust you, I trust you as a fair-minded group of individuals willing to take time from your day-to-day activities to participate in this democracy and make decisions for the government on the only opportunity that you will ever have. I know that it may have taken you away from some other things that may be important to you, but I cannot overstress to you how important it is that you're here today, that you're participating, and that you believe in this great democracy. As I was riding to work this morning, I came in behind a van that said, "Freedom is not free, just ask any soldier." I think we need only ask also any juror. Liberty and freedom is not free. We will not remain a free people without the jury system, and you're part of that system and you're making this happen. Thank you very much for being here.
Welcome. You've been summoned for jury duty, and as a juror, you're joining millions of other Americans this year participating in hundreds of thousands of trials. Jurors are randomly selected from those people 18 years old or older who live in this county and have a driver's license or identification card from the Department of Highway Safety and Motor Vehicles. These selected jurors are then notified to report for jury duty by the Office of the Clerk of Court. Well, that's how you got here. Now let's take a look into what you can expect from this experience. First, let me assure you that our county, the judges, and other court officials are very aware of how valuable your time is and try to ensure your service is as brief as possible. Jurors are summoned for jury duty by the court. While it's unlikely every juror will actually serve on a jury, your presence serves to keep the wheels of justice turning. And because of your appearance for jury duty, many cases will settle on or before the day of trial. Florida law authorizes the judge to excuse individual jurors from duty for various reasons. Some of these reasons are printed on the summons you received. Should you have any questions or problems, contact our jury management representatives. They're ready to assist you with anything relating to your juror responsibilities. Although jury duty is not a formal occasion, we suggest you wear simple business attire. Maintaining the dignity and decorum of the court is greatly appreciated. Just remember, extremes are inappropriate. If you're employed but will not be compensated by your employer for juror service, Florida law entitles you to receive a small fee for the days actually served. If you have any questions regarding juror compensation, speak with a member of the Clerk of Court's office. We think you'll find jury duty a pleasant and rewarding experience. If this is your first time as a juror, it might be helpful for you to become familiar with the types of cases and people who make up our judicial system. The cases brought before trial juries are divided into two general classes, civil and criminal. Civil cases are those in which the parties in dispute come into court for the determination and settlement of their respective rights and usually involves disputes over money. Criminal cases are those in which the office of the state attorney charges someone with a violation of the criminal laws. In both types of cases, the judge is responsible for the conduct of the trial according to the law. There are other people in the court system. The responsibility of the bailiff or court deputy is to maintain order in the courtroom and, following instructions from the judge, to escort and attend to the needs of the jury. The clerk is responsible for indexing and tracking all documents and physical objects entered into evidence in the trial. The clerk may also be responsible for placing jurors and witnesses under oath as the trial progresses. The court reporter is required to keep a verbatim, word-for-word record of the trial so a written transcript of the proceeding can be made if necessary. And then there are the attorneys and those they represent. In a criminal trial, the defendant is being tried to determine whether he or she is guilty or not guilty of violating a state law. In a civil trial, the plaintiff is the party who has filed the suit, and the defendant is the party being sued. They're in court to have a jury settle their disagreement. During the course of a criminal or civil trial, those who have knowledge of particular facts about the case might be called upon by either the prosecution, the plaintiff's attorney, or the defense attorneys to testify as witnesses under oath. Which brings us back to you, the juror. Your basic responsibility is to render a verdict according to the law and evidence presented during the trial. A fair, impartial, and just verdict depends upon the combined efforts of the jury as fact-finders, the judge as the presiding officer and authority on the law, and the lawyers as examiners and advocates. A trial by jury begins with the jury selection process called voir dire, an Anglo-Norman term meaning to speak the truth. During voir dire, prospective jurors are questioned concerning any possible relationships they may have with the parties involved, or if they have any prior knowledge about the facts of the case. The candidness of the juror's response is of the utmost importance because the jury trial system is dependent upon it. The judge and the attorneys will ask the juror specific questions to determine if the juror can be impartial. Each party in a case is given a number of peremptory challenges. A peremptory challenge to a potential juror is one of which no reason need be given to the judge. Each attorney is granted a specific number of peremptory challenges depending on the type of case and an unlimited number of challenges for cause. And should any attorney wish to excuse a potential juror for cause, he or she must state such cause to the judge, who will then rule whether the attorney's challenge is proper. There's no reason for anyone to be ashamed or embarrassed should he or she be excused. When a juror is excused, it is in no way a reflection upon the juror, nor does it question at all the juror's competence. The questioning and challenging continues until the number of jurors needed for the trial has been reached. Before the trial itself begins, the jury will be sworn to well and truly try the issues between the parties and to render a verdict according to the law and the evidence. When the members of the jury are sworn, they virtually become judges on every question of fact presented in the case. A juror is bound to act fairly and impartially. Jurors are not free to act upon their own feelings and emotions, but must use sound judgment and reason and must follow the instructions of the judge. Now let's discuss the trial procedure and your involvement with it. Once the trial begins, the attorneys usually make an opening statement detailing the evidence that will be represented in the case. An important thing to remember, opening statements are not to be considered evidence. Rather, they are each attorney's belief as to what evidence and facts in the case will be presented during the trial. The opening statements are not to be considered in arriving at your verdict. Let's talk about evidence. Evidence involves witness testimony, exhibits, and objects used to establish facts of the case. It might be a document, a gun, a tool, a photograph, or some other tangible thing. Oral testimony of witnesses is also evidence. In fact, most of the evidence in the majority of both criminal and civil trials is witness testimony. You must pay close attention to each witness when they testify. Since you are the judge of their credibility and believability, it's your sole responsibility to sort out the facts from all the testimony and evidence presented in the case. There is another serious responsibility of the juror: confidentiality. During the course of the trial, the judge will advise you that you must not speak to anyone about anything that has occurred in the courtroom. Even talking with your spouse about the case can be an act of contempt, punishable by fine or imprisonment. A prudent policy for you to follow is to avoid even the slightest appearance of an improper discussion. As a matter of fact, should you believe someone has purposely tried to talk to you or talk in your presence about the case, you should tell the judge immediately. While you are in the courtroom, elevators, corridors, lunchroom, anywhere, please make sure you do not talk with the lawyers, their clients, the media, or anyone else who may have an interest in the case. Also, you should be aware it would be in violation of your jury duty to conduct your own investigation of the case. You must not visit the scene of any accident or alleged crime, and you must not make any attempt to question witnesses other than what the judge might permit in the courtroom during the trial when everyone involved in the case is present. Sometimes during the course of the trial, the lawyers will approach the judge to hold private conversations. These conversations are not intended for you to hear because they concern technical points of the law and courtroom procedure on which the judge alone must decide. Sometimes the judge might excuse the jury or recess the court to resolve the matter, either in the courtroom or in the judge's chambers. The judge might want to confirm a decision by researching the law before making a ruling. These conferences are quite necessary to ensure a fair trial for all parties and are not used to intentionally delay the trial. After the parties present and introduce all the evidence, the judge may decide to instruct you on the law applying to the case before the lawyers sum up their cases in closing arguments. While the attorney's closing argument is not evidence, you should listen closely as they are intended to help you understand the case. The lawyers will ask the jury to reach a verdict in favor of their client. Then, if not given before the closing arguments, the judge will instruct you on the law applicable to your case. Pay close attention to the instructions on the law the judge gives you, because you, in turn, must apply the law to the facts you have determined from the evidence you've heard and seen from the trial. You must accept the law exactly as the judge gives it to you, because in a jury trial, while the jury is the final authority on the facts, the judge is the final authority on the law. There is a difference between the level of proof required in a criminal case and that of a civil case. The judge will instruct you during the trial, explaining which party has the burden of proof and the level of proof required in the case. Here are the main things to remember. Although not evidence, listen closely to the attorney's opening statements and closing arguments. Listen to all the witness testimony. Look at all the documents and other exhibits entered in evidence. Listen and read carefully the instructions on the law from the judge. Decide the facts. After the judge submits the case to you, the bailiff or court deputy will escort you to the jury room for deliberations. During deliberations, your first duty is to elect a presiding juror. The presiding juror oversees the deliberations like the director of a meeting. It's the presiding juror's job to maintain order and ensure a thorough discussion of the case takes place, and that each juror is given an opportunity for personal expression. The presiding juror conducts the balloting when the jury is ready to reach a decision. Unless the judge tells you otherwise, the jury's verdict must be unanimous. That is, each juror must agree to the same verdict. It's important for all jurors to listen to the opinions of other jurors, form opinions, state them, and keep an open mind throughout the deliberative process. Then, vote the way your intellect and conscience tell you, based on the evidence and law you've seen and heard during the trial. When the jury has reached a verdict, the presiding juror informs the bailiff or court deputy who will advise the judge and attorneys. Do not tell anyone what decision has been reached. The trial will be reconvened and the presiding juror delivers the verdict to the judge on behalf of the entire jury. So, if you are one of those who might have felt jury duty would be inconvenient, we urge you to think again. Jury duty is the most important civic responsibility of all. America has conducted trials by jury for more than 200 years. We're one of only a handful of countries that do so, and here's why. Because it works. It works because of you, the American juror, serving honestly, conscientiously, with sound judgment, and using good old common sense. Thanks for your time. You'll find it's worth it.